right, so this is a status conference. Matter was referred for mediation. It looks like it was not settled. Is that correct?
Correct.
And this was your motion. Is that correct, sir?
Yes, sir.
And just remind me what you were looking to change.
There was a host of things. The primary one was parenting time.
Okay.
And if I can add to that, I don't know if this is the right time, but I would like to.
Well, in what ways are you looking to change parenting time?
Well, I would like more parenting time. I'd like to eventually get to 50-50. I'm open to, I think that might be abrupt, you know, given that I'm non-custodial and it's every other weekend, and that would be abrupt. But something happened over the past weekend. I think it's made the situation urgent. And so what I'm more concerned about right now, if I put parenting time on the back burner, and I still want 50-50 and I want to get there, that's in a way that's most beneficial for the kids. But what's kind of taken the front burner is I think we need some kind of social intervention. We need help with counseling for Leslie and myself. I can go into I can give you the brief details of what happened over the weekend if you like, but that's up to you.
No, no need for that. I mean, so where we're at basically with this, your motion is, so you filed a motion, you guys tried mediation, it wasn't successful. So the next step that the court would do is set the matter for a evidentiary hearing. The two of you are always able to come to any agreements you wish as far as any participation in counseling or anything else. So if you guys have agreements, you can do that. If you don't have agreements, then it's something we'd have to address at the evidentiary hearing. I do see that also Ms. LeBlanc has filed a motion also that is set for a initial date on December 3rd. Yeah, I think we could combine everything and have our evidentiary hearing and do everything together. So at this point, sir, are you then requesting an evidentiary hearing regarding your motion?
I think it's inevitable. The reason I brought up what I did is, candidly, I was 15 minutes away from calling the police to look for my son. He ran away when we were switching, so that's why I say it's kind of an urgent matter. Even like I have the kids again tonight from 6 to 8. And if we have to wait until December 3rd, I think is the next court date. Okay, but
there's emergency matters, you know, the court can address those through ex parte motions. Those are specifically for emergency matters. There's a higher standard to get those granted, but that is a relief that is out there available for a party. Otherwise, you know, motions have to be taken, testimony has to be taken, and the court has to review those. So that is one option that you have if there are specific issues that need to be addressed immediately. I can't say if it would necessarily rise to that level or not, but that is an option that you can have. Our next hearing date for in-person testimony is December 8th at 9 a.m. Do you have any issue with that date?
December 8th?
Yes.
Okay, so this must be, I have one set for December 3rd, but that's
her new motion, which is, that's a status conference date. That's like an initial hearing. So what we would do is just put everything. So the December 3rd date is just a quick 15-minute hearing to see what she's asking for. But I think we can just move that also, and everybody can make their arguments regarding any changes on December 8th.
All right.
LeBlanc, do you have any?
I'm sorry, what was that?
Do you have any inability to appear on December 8th at 9 o'clock?
I could be there.
All right, and then, so you've got a pending motion also, is that correct?
That's correct. My only hesitation about moving it back is that the motion is so that I would like permission to get the kids' passports for a vacation in January. And I already think it's going to be kind of a tight timeline to turn it around if he
This December 3rd is simply a status conference hearing anyway, so we wouldn't have made a
Right.
decision that day.
Mhm.
So December 8th is the first time I have available to
Oh,
take
okay.
testimony. And
Okay. Yep, if that's the earliest we've got, then that works for me.
that your request for parenting time change is to get passports as well as then switch some time around. Is that correct?
Yes, we have a vacation opportunity in January, and I've not been able to get an answer about getting a passport over the past few months. So I was told that I should request friend of the court's help in getting that.
All right. Is there anything you want to say on the passport issue at this time?
Yes, Your Honor. I still don't even know what country she's trying to take them to. I know there's a cruise that she'd like to go on in January. I've been told that the information itinerary was going to come to me. It has not. So again, this is another reason why I'm asking for something, saying it's kind of an urgent matter. And candidly, my children, that are 11 and 9 years old, have told me about this cruise and how excited they are to go on it. And I don't think that's fair at all, because if she says she wants to take them to Mexico, I don't know how I feel about that right now. The kids can't even walk to the cathedral to go to mass for safety concerns. So yes, I would like to have a conversation about it, but I don't know what country they're going into, and I'm gonna be really the bad guy if I have to say I object to it. And I don't think it's fair that the kids know about it and are excited about it at this point.
Well, I already did
All right,
send
well-
you, I did send you the travel details.
I'll let you guys have those discussions. If it gets resolved, then we don't have to address it. I can tell you that, the court, in order to change a parenting time order, has to find that there's proper cause or change of circumstances. Typically, a party wanting to take a vacation, it doesn't rise to that level for the court to intervene and move parenting dates around. I've had this issue before, and I typically won't do that because I don't think that's what the court is for when it comes to changing orders. But I would also hope that parents can certainly have conversations and
Mhm.
talk about a vacation and figure out what makes sense and what's in the children's best interest, and work together. So hopefully the two of you can do that. If not, we'll address the issue on the 8th. I don't know where we'll get, but like I said, anytime you're looking to change parenting time, you have to show that there's proper cause and a change of circumstances for the court to do so. So we're going to set your matters for December 8th at 9 o'clock. That is an in-person hearing. If you intend to have any witnesses or file any exhibits, you need to file a witness and exhibit list 14 days prior. Additional information will be attached on the notice you receive regarding the hearing date. The date for December 3rd, then at 10:15, that would be removed, and we would simply address those issues on December 8th also. Any questions, sir?
Just to recap, December 8th, 9 a.m. We're going to receive something from the court with all the details you just listed. Okay, perfect.
Yes, sir.
Okay.
Ms. LeBlanc, any questions?
That was my same question, so no, sir.
All right, thank you both
Your
for
Honor.
appearing.
Before you dismiss, are you going to do the child interviews?
Oh, certainly. Is child interviews because of their age. Anytime there's a request to change parenting time, and the court might have to look at the best interest factors, I do have to do interviews. So the children should be here at 8:45 that day. So whoever has them that day needs to make sure they're available at 8:45. And then somebody should be present, potentially take them either back to school or home. All right, thank you for that reminder, and the two of you are all set.
Thank you, Your Honor.
Call the matter of Trevor Drensky versus Melissa Montrian, file number 12-14591 DP. Do we have anyone present on that matter?
Good morning, Juanita Massey appearing on behalf of Trevor Drensky, the plaintiff, who's seated to my right.
Thank you. Schedule for the parties to place an agreement on the record. Don't see the other party present. Is it correct, counsel, that you have an agreement?
Yes, Your Honor. My client and the opposing side came up with this agreement on their own. I wrote it up. He signed it, she signed it, he can testify that he saw her sign it, 'cause he took it to her. She has never called me to object to anything or the entry of it, so it was by consent.
Okay. What are the terms of that agreement?
The agreement is that the plaintiff, Mr. Drensky, shall have sole legal, sole physical custody of the minor child. The child, I believe, is 14 right now.
Mhm.
Yes, 14 years old. Both parties believe that's the change is in the best interest of the minor child. Parenting time, defendant will not have any parenting time until she's attended, participated in, and benefited from a minimum of 2 parenting sessions per month with the minor child's counselor, Carissa Martin Samansky, and the minor child, and she has been doing that since this agreement. And a minimum of 1 parenting session with plaintiff father and the minor child's counselor. If defendant mother abides by the above paragraph, receives a written statement from the counselor she's attended, participated in, and benefited from such counseling sessions, defendant mother's parenting time shall be as follows, unless the parties agree otherwise. Supervised parenting time every other weekend from Friday at 5 to Sunday at 6. Unless the parties agree otherwise, defendant's father, Terry Barton, defendant's grandmother, Sharon Mott Bryan, defendant's mother, Kim Mott Bryan, or defendant's friend, Chris Overly, shall be the supervisors for parenting time. The child will spend all overnights at the Sharon Mott Bryan's house or Terry Barton's house during the defendant's parenting time. Child will spend all overnights at Chris Overly's residence during the defendant's parenting time too. So any of those places are appropriate. Holidays as the parties agree. Summer vacation, no summer vacation unless the defendant mother complies with the counseling sessions. Then if she does, then there's still be supervised parenting time every other weekend. From Friday at 5 to Sunday at 6, unless the parties agree otherwise, defendant's father. So those same parties that I just mentioned would be the supervisors. Parents can agree to change parenting time. Obviously, the parties have to exercise parenting time, make sure homework's completed, child's transported. There's some restrictions for the mother. Defendant mother shall not use any non-prescribed and or illegal drugs or alcohol during her parenting time and shall not drive with the child or allow anyone to drive with the child while she or any driver is under the influence of any drugs or alcohol. Defendant mother will submit to random drug and or alcohol testing as requested by the plaintiff. Defendant will be responsible for the cost of the testing. Defendant mother will provide copies of her Alcoholics Anonymous meeting attendance documents to the plaintiff father as requested by the plaintiff father. Defendant mother's failure to submit to drug and or alcohol testing or provide copies of her AA meeting attendance documents may result in defendant mother forfeiting her parenting time until she complies. Obviously, Hague conventions and not moving the child out of the state of Michigan, all those are continue to comply.
All right. So you have that all drafted up in a proposed order?
Yes. We submitted that
all
to
right.
the court.
Did the court have a copy of that?
I thought it was in the file.
Okay. Thank you. Last page I have, counsel, does not have your signature on it.
Okay, I can submit a copy of my signature. I don't know why mine
Okay.
wasn't on there.
All right, Mr. Drensky, would you please raise your right hand? Solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
All right, sir, you put your hand down. You heard the
Okay.
terms outlined by your attorney. Are those the terms that you're asking the court to adopt?
Yes.
And you do not have mom present here. It does show that she signed that. Are you indicating that you were present with her when she signed that?
I was. I'm sorry, excuse me. I was present. Yes.
The two of you have discussed these terms and come to that agreement.
Yes.
And is it correct that she has been participating in some of these parenting sessions already?
She has. Yes.
Okay. Do you feel this agreement is in the best interest of your child?
I do.
So what I'm going to do, counsel, is indicate you need to give us a copy with your signature on there. And then I'm going to recommend that we enter this as a recommended order just to give that 21-day objection period in case there is some issue from mom's perspective. It is signed. Dad has testified that this was their agreement. She's not here today, which I certainly prefer to have her here to confirm all that. Given the status of this matter, I'm comfortable submitting it as a recommended order. So if she did have some sort of change of heart or some other issue, she would have the opportunity to file an objection and have that dealt with. Any questions, counsel?
Just can I submit that signature page with by email to your office?
Certainly.
Okay,
Yes.
thank you. No other questions.
All right, thank you. You're all set and can sign off.
Thank you.
Thank you.
Present in front of the court, what is the status in this matter?
On September 11th of this year, a bench warrant issued when the defendant failed to appear. The defendant did contact a friend of the court on September 18th, and a stipulated order entered September 19th for her to appear today and provide friend of the court with appointment details after her appointment with community mental health that she reported was on September 29th, and any information regarding her inability to earn income. The defendant's support obligation is $302, a balance of $3,799.50. The last payment that was received was a non-voluntary payment of $502 in March of this year.
Thank you. Ms. Johnson, what would you like to say?
Well, I've recently started working 2 jobs, but my second job, I got a call at about 10 o'clock yesterday morning, I want to say, or the day before yesterday. And they basically called me up and accused me of, like, I guess sleeping on the first day, but I was like, well, I don't know. I could see how the misconception would occur because I haven't worked at that kind of nursing home setting in a while. So I came across it. I thought I came across as nervous, but I guess to other people I came across as a little sleepy. So they let me go on my second one. And I'm trying to actively search for another one, but I've still got my Qdoba, and I do want to make a payment with my second paycheck, which will be not this Monday, but the next Monday.
Okay. Have you reported that job yet to your caseworker?
Yes, sir. I'm just having a
For the
hard
court, did you
time
know
with my
about the
video.
job at Qdoba?
I wasn't aware of it. She had contacted me, left a voicemail. I attempted to return her call, but her voicemail was not set up, and I hadn't had any contact since.
All right. And how long have you been at Qdoba?
I've been there for about 2 weeks by now, because my first was on the 13th, but they've been giving me a lot of hours, so it's been hard to call anybody.
All right. Do you have a paycheck coming?
Yes, sir. I have the option by pay card. We have like either a pay card option or a direct deposit, but I don't have a bank, so I chose I'm sorry, my chitlins are a little loud. I chose a pay card.
All right. Well, you need to make a payment.
They blocked your video.
All right, you need to make a payment on this case from your paycheck until there's income withholding order in place. We'll work on establishing that. I'm going to
Yes, sir.
adjourn you to December 3rd to follow up on the income withholding order. But again, until money's coming out of your check for support, you need to make payments directly, okay?
Yes, sir.
All right, you are all set for today. We'll see you December 3rd.
See you December 3rd. Thank you so much, Your Honor.
Thank you. Mr. Jesus present. In front of the court, what is the status of this one?
The plaintiff has a support obligation of $133 with a balance of $1,773.60. Partial payments were received from November to as current as February of this year. The last income withholding amount was $37.11. The last time the monthly obligation and money towards arrears was received and met was in October of 2024. It does appear that the plaintiff has filed a motion regarding custody and support that's set for November 5th. Based on that information, potentially adjourn it, but I would like to indicate if she is employed, because she has reported she was employed in July, but there's been no payments.
All right, thank you. So I am likely just to adjourn this matter. It looks like Ms. DeJesus, you filed a motion that's set for November 5th.
Yes,
So I think it would make sense to adjourn that to that date. Are you currently working?
yes, I am.
All right, if you could just provide that information to your caseworker.
Yes, I'm waiting for, okay, thank you.
Thank you. You are all set. I'll see you back here November 5th.
Thank you.
This hearing was adjourned from September 10th to confirm the reported payment that he had made that morning of the hearing. Since then, the $100 credit card payment that was made that morning at the last hearing, $18.95 was dispensed specifically to this case on September 16th. The defendant did report he is employed on October 1st and was instructed to self-pay until the income withholding is active. Friend of the court again had contact on the 8th to give today's hearing information, and he indicated his first paycheck would be on October 10th. There's been no payments received. The defendant's support obligation is $203. The sum is composed of $135 for current support and $68 for overdue support, and has a balance of $15,077.39.
Thank you. Mr. Johnson, what would you like to say?
I'm currently working and I'm just trying to play catch up.
Okay. Have you gotten a paycheck yet?
Yes, and I'll be making a payment today.
All right. How much are you making payment for today?
By $100.
And so, front of the court, you do have the income withholding, the job information.
As long as he's still employed at the same place he reported the first part of
All
October.
right. Same job, sir?
Yes, Buffalo Wild Wings.
Okay. All right. So as indicated, make sure you're making payments on your own until it starts coming out of your check. Just to make sure all that is happening, though, I will reset you for. Let's go December 3rd. So again, sir, just make sure you're making the payment directly if it's not coming out. And then
Okay.
we'll come back December 3rd to make sure you're doing that, and then also to see if the income withholding order is collected yet, okay?
Okay, sounds good. Thank you.
Do you want the order for today indicating that he's to make that $100 payment that he's stated he was doing?
Yes, and he's indicated he's gonna make that payment, so he does need to do that, and then as indicated, make an additional payment if it's not out of his next check. All right, thank you, Mr. Johnson. You are all set for today.
Thank you.
Jessica Schultz present.
Thank you. From the court, what is the status of this file?
This hearing was adjourned from September 10th when the defendant failed to appear, but the friend of the court recently received a verified address. A default judgment of support entered on August 8th of 24 with an effective date of March 8th of 2024 through the prosecuting attorney's office. The defendant's support obligation is $703 with a balance of $13,973.50. There has been no payment since the order entered, and we've not had any contact with him either.
Thank you. Ms. Schultz, anything that you would like to say or any questions that you have?
Just that his sister had come up a couple weeks ago. He is in the process still of filing for disability, but nothing further, even what you guys have seen on your end. There hasn't been anything further. He's not in any shape, his sister thinks, to take Adam or see Adam. But I did relay the message that if he were to get into rehab, you know, we could meet in front of you. And if he graduated from rehab, he could get some of this, you know, get some time back with his kid and get some of this taken care of. But we're not sure that he's even mentally capable of taking that message is what we're afraid of. So no one's seen or heard of him. No one really knows where he's at in Jackson. He pops into his sister's from now and then, but not enough to keep dibs on. So
Do you know at all when he last worked?
when he was up here, he works for cash just to get by, to get what he needs. He's always asking for a couple bucks, his sister says. So he's not working actively. He's wrapped up in drugs. He's got sores and tumors all over him, is what his sister said. I did not see this, but he's pretty deep in drugs and needs help, but not the kind of help that family can provide.
Looks like when his support order went into effect, they indicated he was working at Lexmark. Did he have that job at some point?
Yes, and he was on disability until he was 18. He was electrocuted as a child or as a baby, a toddler, brought back to life. And when he turned 18, he decided he didn't want to be on disability. He worked for several factories, even was vested at Brembo Brakes down in the Jackson area. He had almost 10 years there, 9 years there, or 5 years, something like that. Anyway, he got into drugs and lost that job, quit that job. And that was, Adam was born in 2017. So that was right about 2019. He quit that job. Didn't have a job until he moved up here. And right around the time, because my mom was trying to help him get sober, I tried hiring him, but it didn't go well. And he did have several jobs up here. He'd get the job and then they'd fire him for whatever reason, or he'd quit. I don't know. There's various stories that the employer didn't want him or he didn't want to do the job because, you keep a job for a couple weeks and then child support starts to come out. It doesn't take long if you're doing a W-2. So I don't know. Either way, if he wasn't wrapped up in drugs, there's jobs he could do. He could be making good money. I offered him $20 an hour, but he couldn't show up and he was not right. And that was in 2000. I got my license in 2023. So right about the time I got Adam, I was trying to work him and couldn't show up. And when he showed up, he was on things that he shouldn't be on because he's slow. We call him Timmy the Turtle because slow and steady wins the race. As long as you're not doing drugs, he can, in a factory, in a production setting, and he's sober, he might not be as fast, but he's a little slower, so he's more meticulous, and he ends up with the same number of parts as the fast guy. So I wish he wasn't wrapped up in drugs. We're going to take Adam down to see his aunts right around Halloween, but not to see his dad. So it's hard.
So
I wish he would.
Kind of two options. I
Can't
can
make
adjourn
it.
this out, see if we can get him to appear, or I can issue a bench warrant because he hasn't made any payments and he has not appeared. Do you have any input on those options?
I'd like to see him get clean and sober. If the address is 2000 Cooper Street, you don't have to tell me the address, but if it's 2000 Cooper Street, that's the jail.
All right, that's not what we have. No, I think we got a verified address recently. So I think
Okay,
we've got
and
the
his sisters live in not Michigan City. They live just outside of Jackson. So, and his son lives in Jackson.
Want to give me any input on what a bench warrant, or if I adjourn this and give him another chance to appear?
Can we adjourn it for a month? I would love to see him get sober. And I know that it's not right to drop that much child support, but if he could sign him into recovery, I'd be more than willing. I don't need the money. I need him
a chance to appear. So I'm going to adjourn him. I'm going to adjourn him to December 3rd.
Sounds good.
And we'll send another notice out. And obviously, if you have any contact with him or his family, you can let them know that he does have that court date. All right.
Okay.
Thank you for your information.
Thank you. I'll put the word out that if he's somewhere else, he needs to give a better address too.
Okay. Thank you. You're all set.
Thank you. Have a good day. Bye-bye.
The matter of Melissa Morrison versus Jesse Morrison, file number 23-19363 DM. What is the status of this matter?
The defendant has a support obligation of $88 and a arrearage of $400 and has not made a payment since July of this year. The July payment was $300. It looks like we've not had any contact with the defendant regarding the show cause.
Thank you. Ms. Morrison, anything that you would like to say?
No, Your Honor.
Given the failure to appear, then I will recommend the bench warrant to the amount of $500 plus $100 in costs. Thank you, Ms. Morrison. You're all set.
Thank you, Your Honor.
All right, so we're here today. A couple matters. One is a show cause hearing as well as any update regarding genetic testing. So Mr. Fox, as to the testing, anything that you'd like to say?
No, I had it done through the like prosecutor attorney's office.
Okay. Do you have any information on Ms. Bourne's testing?
No, I do not, sir.
Part of the court, do you have any updates on whether or not she has had testing done yet?
No, I just can see information from the prosecuting attorney's office that they are contacting her, but as of the 17th of this September.
All right. So what I'm going to do is adjourn the matters out to follow up on that contact with her participation. Give it a little more time, so I will adjourn to December 3rd to see where we're at. And I would also indicate then we should also do a show cause against Ms. Bourne for failing to appear today. Perhaps that will motivate her more to show up for these matters. Mr. Fox, if you get any information in the meantime, as far as whether or not she's tested or not, make sure you share that, but the front of the court will also keep track to see if that is done. If she doesn't appear next time and hasn't complied with the testing, the court does have some contempt matters that I can certainly employ to try and get the testing done. Any questions, sir?
No, sir.
All right. Thank you for appearing. You're all set.
Have a great day, sir.
Thank you.
Bye-bye.
This is a motion regarding support. And Ms. Couch, this is your motion regarding some medical reimbursement. Is that correct?
Yes.
Mr. Mendoza, have you got a chance to review that?
Yes, Your Honor.
Do you have any objection to her request or anything that you'd like to say?
No, Your Honor.
Okay. So it looks like we have a couple different support orders that went into place, which sort of changed some of the percentages. I think in front of the court, you have broken that down. Is that correct?
Yes.
Okay. Can you kind of give me the breakdown?
So prior to May 13th of this year, the percentages were 60% by the plaintiff, 40% by the defendant, and the ordinary medical expense was $454. Based on my review of the documents, it looks like the defendant paid $2,570 around April of this year. She was reimbursed by insurance $1,515, which would be $1,055. If you subtract the 1,055 minus the 454, that leaves 601. Multiply that by 60%, that leaves $360.60 that the plaintiff would be responsible for out of the April bills.
Okay.
And then after that, it was a little unclear on what has been paid and what would be left owing. But anything after May 13th, the plaintiff is 55% responsible for and defendant 45%.
So Ms. Couch, what are your expenses after that date?
Everything is already paid in front, like all the medical bills that are there, they're all paid in full. So I've paid all of everything so far.
Okay, have you tallied that up or not?
I believe it's in the paperwork. Sadly, I don't have that paper in front of me. I had a family emergency and did not grab those papers. The biggest bill was the one in April, though. Everything else is probably tallies around $300 to $400.
Okay. So, sir, you would agree then that that first bill, given that mathematical breakdown, that you would owe $360.60 for that bill in April, the Delta Dental service? well, through Grand Traverse Oral Surgery, but yes, sir. So that's $360.60 for that charge that was about $2,500. Insurance covered about $1,500, left about $1,055 left. We take out the ordinary medical, leaving a total of $601. Your percentage of that is 60%, which is $360.60. Do you agree with that, sir?
Yes, Your Honor.
Okay. And then looking at your paperwork. Other than that bill, I see. Looks like some charges from Old Town Psychological. Is that correct, Ms. Couch?
Yes.
It looks like you paid $277.62. Is that correct?
Yes.
All right. So you're requesting reimbursement for that?
Yes, please.
And the percentage is 55. Is that correct?
Yes, it is.
So I'm looking at 153. Any objection to that amount, sir?
No, Your Honor.
Any thoughts? So the total's five. Lost my math. 153. No, it's 360.60.
Yes. I got 513.60.
Right. So 513.60 is your total, sir. Any thoughts on how you want to make that payment?
I was under the assumption that it was just going to get added into my total.
Okay. Well, there is a way to disperse it through the child support. So that's your request, is that we add it into the child support and cover it through that?
That'd be the easiest way for me, Your Honor.
Front of the court, any issue with that?
No, we can do that, and then we can have you charge off at a specific amount per month.
So, sir, how much per month do you think you're comfortable adding on at this time?
$54.
Ms. Couch, anything you want to say regarding that?
No, Your Honor.
All right. You're okay with that figure, ma'am?
Yes.
Okay. All right, so we will charge it off at an additional 54 a month. So that would probably hit in November?
Yeah.
Okay. All right. So beginning in November, your support amount will be increased $54 a month until that 513.60 is charged off. Okay.
Yes, Your Honor.
Anything else, Ms. Couch?
No, that's everything, Your Honor.
All right. Thank you both for appearing. You're all set.
Thank you.
Thank you.
The matter of Ashley Ortiz versus Morris McCaleb, file number 23-19527 DM. Do we have anyone present on that matter?
Yes.
Thank you. We have Ms. Ortiz present. It does not look like Mr. McCaleb is present. And Ms. Ortiz, this is your matter regarding pairing time. Is that correct?
Yes, it is.
And Ms. Ortiz is Kyle Ortiz in Sheboygan County related to you?
Yes, he's my brother.
All right, so given that, I also work in Sheboygan County as the referee there, so certainly I work in direct contact. He is in some essence also my supervisor for that work. So I do think it's appropriate that I disqualify myself under MCR 2.003 C1B. I think given that relationship and contact with direct contact with your family member in the employment creates a potential appearance of impropriety. So I do think it's appropriate that I disqualify myself. So this matter will be reset before Judge Hessel.
Okay.
So Ms. Ortiz, the court will reset that. You'll get a notice for that new hearing date, okay?
Okay. Is that still going to be through Seago?
Yes, it'll stay in this county. It'll just go directly to the judge and skip the referee process, okay?
Okay. All right. Thank you.
All right, thank you. You're all set.
Yep.
What is the status of this matter?
Certainly, Your Honor. We were in last time, and since then, the parties have mediated. They did a great job at mediation and reached a resolution regarding custody and parenting time of the minor child in this case. We do have a hearing coming up next week. We're working on a judgment. We've also submitted a proposed order to enter the mediation agreement as an order that lays out the terms of the agreement regarding custody and parenting time. I could read that into the record as well, if the court would like the parties to acknowledge that they believe the custody and parenting time arrangement is in the best interest of the minor child.
Okay, well, you've got a conference in front of Judge Hesselink coming up next week, you said?
Yeah, next Friday, the 24th, I believe.
Okay, and the plan is then to hopefully have the judgment prepared and put everything on the record then?
Exactly, yes.
Okay, well, I don't think we need to necessarily do it on the record today then, unless you really want me to do that.
No, I think it's okay to table it for next week, so it's not redundant.
Okay. All right, Ms. Fiol, any issue with that process?
I just want to confirm that if we do proceed next week or whenever that date is to put that into effect, I do have the right at any time to change my mind and file a motion with the friend of the court. Is that correct?
Well, anytime parents have an agreement on custody and parenting time, if things change, if there's proper cause or change of circumstances, a party can always seek for changes to the custody and parenting time arrangement.
Okay, thank you so much.
Okay. All right. All right, then. I don't think we need to do anything on the record today, given that the parties have a hearing next week in front of Judge Hesselink. Obviously, if issues arise and there is no agreement, then you can come back if an evidentiary hearing is necessary.
All right.
Your Honor.
Yes.
Thank you.
Just indicate that there hasn't been a judgment submitted to our office for approval and support hasn't been addressed yet.
All right.
So
Mr. Chapman has to support. Are you asking the court to do a recommendation?
That's a good question. We didn't contemplate child support during the mediation process. And so I know the friend of the court probably doesn't have an overnight calculation either anyway. If it would help while we're here, my calculation is that there would be about 104 overnights for Mr. Fiol absent the holiday parenting time. And so maybe I will put a little bit on the record so that the friend of the court has some information to keep things moving, Your Honor. The mediated agreement would be that Mr. Fiol has an overnight every week and parenting time overnights every other weekend. So Friday to Sunday. So Friday overnight and then a Saturday overnight every other week. And then every week a weekday overnight. And then holiday parenting time would be as the parties agree. And then if they don't agree, they would resort to the 46th Circuit standard holiday parenting time schedule. So that's where I was pulling the approximately 104 overnights plus the holiday parenting time overnights. And so, yes, we have not submitted the proposed judgment to the friend of the court yet. We're hoping to circulate that to the parties today and hopefully get that to the friend of the court by the end of this week then for their approval.
Yeah, we'll hold off on having a recommendation done. That can be addressed, I think, at the hearing in front of Judge Hesselink then next week to give you guys some additional time to have those discussions.
All right. Thank you.
Thank you. Any questions, Ms. Field?
No, sir.
All right. Thank you, everyone, for appearing. You are all set.
Thank you.
Thank you.
Thank you. So we were set for a status conference. The parties were going to attempt mediation. It looks like there was some difficulty in getting Mr. Brown to participate. So what is the status of this matter, ma'am?
I am unclear. I am not able to get a hold of him at all. Either I've sent him an agreement that I'm willing to agree to that I sent prior to mediation so that he could go into mediation with what I was asking for, and he has not contacted me. He still has not contacted me. The only time he's contacted me is to let me know he got in a car accident and to let me know that his child was being born.
Okay, is he exercising any parenting time currently?
No, he has not exercised parenting time in over a year. The only time he has exercised parenting time is when I went out of my way to bring our kids to Traverse City to see him.
All right, so I'm going to give you a couple options on how we proceed next. We can either set the matter for a evidentiary hearing, where the parties are to come to court, present their arguments and their side of the case. Or if you think some additional communication between the two of you might resolve the matter, we could set it for another status conference in about 45 to 60 days. What are your thoughts?
I've definitely tried to contact him. There's no way to get contact. He has other things in mind. He's definitely into some things that I don't approve of. So I would like to just kind of go and take it to the court at this point.
Okay. At a hearing, do you think you would call witnesses or just be your own witness?
I can be my own witness, but I do have plenty of witnesses on my side and on his side of the family as well.
Okay. Well, it's up to you on if you call witnesses or not. I just ask because if there aren't going to be witnesses, I usually just set the matter for an hour. If there's going to be witnesses, it certainly would likely take more than an hour, so I would give some additional time. So would you like more than an hour?
Absolutely. I would like to bring some witnesses.
Okay. So I'm going to set your hearing date for December 10th at 1 p.m. That is an in-person evidentiary hearing. If the parties intend to call any witnesses or submit any exhibits, you do have to file what's called a witness and exhibit list. Information regarding that will be provided with the notice that is sent to you for that hearing date.
Okay.
Looks like the children are fairly young, so there would not be a child interview. So we will see you here then, ma'am, in person on December 10th at 1 p.m. Okay?
All right. I'll see you then. Thank you.
All right, thank you. You're all set.